Good morning, everyone. Hope everyone's well this morning.
Good
Good
morning, Judge.
morning.
Good morning, Your Honor.
Good morning, Officer Milton. Hope you're well.
I'll be better if I can go first.
That's up to you in courtroom too. So um, just let me know. Let me take care of a matter first. I see that we have a plea in absentia this morning. Robert Ward, Attorney Mashburn. I see that you're on the line with us.
Yes, Judge, I'm here.
Yes, let's see. Do we have a prosecutor on? Are the prosecutors on the line yet?
We do, Judge. State is here.
Okay, good morning, Mr. Sirocco. Let's go ahead and take care of this matter. Attorney Mashburn, if you can come on camera for me, please. Where is Robert Ward at the present time?
He is in the Forsyth County Jail, Judge.
Okay, and it's in this case 26 CR 002259B. Mr. Ward's charged with theft by shoplifting. Is there a negotiated plea?
There is, Judge.
Yes, Judge,
Yes.
there is.
Go ahead, Mr. Sirocco.
Yes, Judge. On the charge of theft by shoplifting from March 18th, 2025, it's docketed at 26 CR 002259B. The state's recommendation here is time served.
How much time has been served?
I don't have that information, Your Honor.
And is there any reason, I mean, I have on the plea calendar that the recommendation was an anti-theft class, a $500 fine, and stay away
Right.
from the target.
There was an offer that was not communicated to me that was already relayed to defense, Judge. So it was a lapse in communication there, but the previous offer and the one that I will honor that was made by Deputy Chief Rhodes, Judge, is for time served here.
Okay, and again, if you can tell me how much time was served. I want to know why this is a different type of plea than normal. I mean, this is normally the state's recommendation. If he's been in custody for a good amount of time, then I'll accept the plea. If that's the case,
Judge,
otherwise I need an understanding of why this is different than any other normal, looks like a first time theft by shoplifting. Yes, Ms. Mashburn.
Judge, he has been in our jail for a little over a year. He's been in since 3/23/25.
Okay. And the time served, that's your understanding of the offer, Ms. Mashburn?
Yes, Judge, it is.
Okay. And have you all prepared the paperwork in regards to the plea in absentia?
Yes, Judge, we have.
And you've gone over that paperwork with Mr. Ward?
Yes, Judge, I have.
Okay, very good. If you will get that to Ms. Young, who is the litigation manager today, she'll get it to me and we'll get it signed and entered.
Okay, Judge, I believe I've already sent her the paperwork, but I can send it again.
Okay. Good morning, Ms. Young. Do you have the plea paperwork on this?
Hold on, Your Honor, I'm looking at it. No, sir, she did not send it to me.
I think it may have been sent to Ms. Lewis, Judge.
Lewis is not the case manager.
Yeah, no, I understand, but Ms. Mashburn had been working on this case last week, so.
Okay.
I'll
So
ask-
if you just make sure that we have the paperwork, Ms. Mashburn, if you can follow up with Ms. Young to make sure that we have it so we can get it signed and entered.
And so, Your Honor, we're not using the amount of days because when he was last in our jail, he did 128 days, so.
With just time served, we fine for the paperwork.
Yes, sir.
All right. Anything further this morning, Ms. Mashburn?
Just to be certain, Judge, Mrs. Young, is your email SHANELL.young@fultoncountyga.gov?
That's correct.
Okay, I'll send this to you right now. I apologize.
That's okay.
Okay. Have a good day. Ms.
Thank you,
Mashburn.
Judge. May I be excused?
Yes, ma'am. Have a good day.
Thank you.
Mr. Deland, good morning. I see you're down for position 13, Jade Goulbourne.
Good morning, Judge. Yes, sir.
Okay. I have also that a public defender spoke with him. What would you like to do with him or her? What would you like to do with them this morning in regards to the charge?
Judge, I'd just like to enter a plea of not guilty for now and file for discovery. She's got some felony charges we're dealing with right now, and that's what's keeping her in custody.
Okay, so if you'll file a waiver, we'll return it to the division judge, and she'll get notice, and you'll get notice of her next calendar.
Thank you, Judge. That was filed already, and so it should be in the system, but I appreciate that.
All right, very good. Anything further this morning on this matter?
No, sir.
Have a good day.
You too, Judge.
Any other private attorneys have announcements on their cases before I get started?
Good morning, Your Honor. Addison Wade for Mr. Miller, whose position I believe 24, sir.
Okay, good morning.
morning.
24. And what are we doing with Mr. Miller this morning?
Yes, sir. We were up a couple weeks ago. He has some pending matters in Superior Court. The bond on this case is set at $4,000, 10%. He's been in custody roughly 30 days. I had asked for a bond reduction last time, and you had wanted to see what would happen with the Superior Court cases. He is still sitting no bonded on one indicted case in Superior Court, and a second case is about to be indicted, I believe, this week. So I'm here just to ask for Your Honor to consider reducing the bond in this case. Reckless driving, count one, laying drags, driving suspended, traffic offenses, no accident, no injuries. He won't be getting out today anyway, sir. So that's why we're here today.
Okay, do we have position 24, Edward Miller in courtroom 2 there?
In front of you, Judge.
Okay, thank you. Good morning. Mr. Sirocco?
Yes, Your Honor. We would still object to any reduction in the bond here. We think that the bond, the 4,000 total through surety through with the 10% is appropriate as it was on the day that you set it. On the 16th of last month, this is still a public safety case. All of his open felony cases that involved driving, aggravated assault against a law enforcement officer. There was a driving while license suspended or revoked there. That's the case ending in 2141. Fleeing and eluding, that's again still open. And that is several other driving offenses as well. The PI case ending in 2142, as well as the other fleeing and eluding from that one's docketed at 2143, case ending in 2143. And with this case, as well as FTAs from 2021, I believe his license has been suspended since 2021, Judge. And with priors, we are recommending that the bond remain as set. We think it was appropriate then. We think it's appropriate now, and we don't think there's been a change in circumstances here in any real sense.
Given the posture of the case, Mr. Wade, I'm going to leave the bond where it is at the present time. If he does make bond on the other matters, you can surely come back and seek for a modification at that time. But until that
Yes, sir.
happens, we'll keep the bond where it is.
Yes, sir.
Anything further with Mr. Miller this morning?
No, Your Honor.
Okay. And has a waiver been filed in the matter?
Yes, sir. I believe I filed my entry, discovery demands, proper waiver, so it should go back to Judge Porter in
right.
due course.
All right, very good. It'll be returned to the division judge. Have a good day, if nothing further.
Thank you, sir. You too.
Thank you. Okay, let's see. ACDC courtroom 2 had requested to go first. Is that okay with you all?
It's fine.
Okay. Officer Milton there? Okay, given that she stepped away, who can we take first? Oh, here she comes.
Who's number?
She's back. I almost skipped over you there, Officer Milton.
Okay, sorry, Your Honor. Ms. Harkness, position 14.
Hi. Hello, everyone.
Good morning, Ms. Harkness. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Nothing but the truth, I promise.
Thank you, ma'am. You can place your hand down. This is a negotiated plea, Mr. Haddad.
It is, Judge.
Okay, yes, Mr. Sirocco.
Yes, Your Honor. For position 14, count 1, the simple battery family violence, the state's recommendation is 12 months, served 44 days. Credit for time served, balance probated, recommending an MHET, 8-week anger management, no further contact with Gladys Harkness, and stay away from 937 Ashby Circle in Atlanta. As for count 2, the possession of marijuana less than an ounce, the state will null pros that upon acceptance of the plea to count 1. We would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea. And if we could sound for Gladys Harkness at this time.
Ms. Harkness is with us and wishes to address the court. Now is your opportunity to do so. Does not appear so, Mr. Haddad.
Judge, we stipulate for purpose of the plea. I would ask the court to consider waiving the first 2 months or maybe 3 months probation fees, Judge. My client's 22 years of age. She's obviously presently unemployed. She's completed high school, had 1 year in college. The victim is her mom. She does have a 1-year-old that her cousin is taking care of, so she's got a place to stay with the cousin. I would just ask in terms of, in light of the anger management and all that, just give her a little bit of time to get her herself situated, Judge. So the first 2 months or maybe 3 months would be great, Judge.
Okay. Ms. Harkness, it's my understanding that in case 26 CR 001970G, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes.
You don't, okay, listen, you don't, you understand you have a right to a jury trial. And because you are pleading guilty to this charge, you're giving up that right to have a jury trial. You understand that?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir. I was met with a deal.
Okay, so nobody has forced you to enter this plea this morning, is that right?
Yes, sir. That's
I'll accept the plea as negotiated, Ms. Harkness. I will waive the first 3 months of your probation fees to help you get on your feet. And when you complete the terms of the probation, I'll have it go to a non-reporting status, okay?
yes, sir.
All right, good luck to you, Ms. Harkness.
Good luck.
Thank you, Judge.
We go to number 3, Mr. Cole.
Right. And
It's a negotiated plea, Judge.
thank you. Attorney Beverly Taylor, are you with me?
Yes, Judge.
Ye-
Good morning.
Yes, good morning, ma'am. This is on position 32. Brandon
Yes,
Sershian. It's my understanding that the state is requesting a week reset on this case. It might be a felony transfer. So I'm going to allow them until next week, which is the 21st. So if they haven't transferred it by next week, it'll be back on the SAP calendar. If they do transfer it, I'll sign a transfer order.
Okay, that's 321. Judge, what is that case number?
23 CR 005370C.
3CR 005370C.
That's correct.
Okay, all right. It wasn't already in state court, Judge, with the judge?
They're seeking a transfer, a felony transfer, and have requested a week to get that accomplished. Okay,
All right, Judge. So you resend it to March 21st.
April 21st.
I'm saying, I meant April 21st, the same all-purpose calendar.
Yes, unless it's transferred. If it's transferred, you'll get notice of that.
All right, thank you, Judge.
Yes, have a good day, if nothing further.
You too, Judge. Thank you.
And Mr. Sershin, if that's you standing there, we will be with you next week, possibly.
Judge, is it any way I can go into a breakout room with him? Do you all have breakout rooms?
Oh, just give me a nod. I have him call you right now. Yeah.
Okay,
Phone call.
okay. We'll place him on the phone with you.
Thank you, Judge. They're gonna
You're
put a
welcome.
phone number in the chat.
Well, you give me your number in the chat. Whichever work for you.
Okay. All right, I put my number in the chat.
Okay.
All right. All right, tell me again, where are we, Mr. White?
Position 3, Judge.
Thank you. Good morning, Mr. Cole. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Say it again for me, please. Still can't hear it. Okay, thank you. You can place your hand down. Yes, Mr. Sirocco.
Yes, Your Honor. On the possession of dangerous drugs, this is again position 3, Mr. Cole. State's recommending 12 months, served 24 days, credit for time served, balance probated, Op 21 law and decision-making course, 30 hours community service, no unprescribed drugs while on probation. We would not have an issue with this going non-reporting. We would certainly have an issue with this going with this terminating the probation. We would ask the defense stipulate a factual basis, venue, and ID for purposes of the plea. That should be it for the state.
Mr. White?
Judge, we would ask if you accept the police negotiated, stipulate the purpose of the plea. We would ask that probation terminate once he completes everything. This is a 2021 case. It's actually over 5 years old at this point.
It does look like he has an open felony drug case out of Haralson County. So that's why we'd ask that it would, at the very least, go non-reporting, but certainly not terminate.
Okay. I have nothing further. Mr. Cole, it's my understanding that in case 22 CR 001502A, you wish to plead guilty to possession of dangerous drugs. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. Cole. I will waive the first 2 months of the probation fees. That should give you enough time to get that course and the community service done. Once you complete the terms of the probation, I'll have it go to a non-reporting status, which means you'll still be on probation, but you won't need to report and pay those fees. Okay? Good luck to you, sir.
Thank you, Judge.
You're welcome. Mr. Murphy, do you have announcements on your cases this morning?
Judge, I have position 17.
Okay,
And
and
that's Ms. Vasquez, and she's over at ACDC. And I had seen the offer, but we're going to decline it. We just want to argue bond when he reaches.
Okay, thank you.
I'll get out, right? I'm getting out.
Okay, and this is position 17, Ms. Avaskiv.
Yes, Judge, that is,
Okay.
or I
What
mean,
is
that's,
the,
I'm not, that is my client, to say.
okay,
Somebody-
just so I'm sure, Officer Milton, this is position 17? Is there anyone there with Ms. Avaskiv?
Officer Milton. What? He said if there was anyone. It's not on you.
I know, but I'm trying to get an understanding of who this is. Position 17? Okay.
Vasquez, 17, yes, Your Honor.
Okay, thank you, thank you. What's the present bond?
Your Honor, bond's currently set at a $3,000 total surety. That's $1,000 for each charge: criminal trespass, damage to property, simple assault, family violence, and willful obstruction.
Okay, Ms. Stallworth, good morning. Can you give me the history, please?
Good morning. Yes, Your Honor, there are 20 cycles. There are 3 2025 FTAs from Fulton, 1 from 2024 from Johns Creek. There's a 2024 non-fingerprintable offense from John Creek. One moment. There's another FTA in 2023 from Sandy Springs. A driving while license suspended or revoked from 2023 in Sandy Springs. 2024 Johns Creek non-fingerprintable offense. A criminal trespass, family violence from Fulton in 2020. Another FTA in 2020 from Fulton County. There's a 2020 conviction out of Fulton for disorderly conduct, 3 counts of that. A theft by shoplifting out of the cab in 2017. That's first offender. Nothing further.
Anything further, Mr. Murphy?
Yes, Judge, my client's age 26. She doesn't have the resources to make the current bond. We'd ask the court to consider a signature bond. She's been in custody for, I believe, since the 30th. She's now consulted with a social worker. She has plans to enter a halfway house either in Roswell or Marietta. And in the meantime, she'll be placed with a friend for a couple days until the halfway house is available. But she's aware of the severity of the charges, and she won't return back to her mother's house, who's the alleged victim. And she'll need a one-time visit for some possessions that are still over there. But otherwise, she does have a plan in place to try to turn her situation around via a halfway house for women in similar circumstances.
And
So we'd ask for a signature bond or a reduction in the bond so she can actually get released on misdemeanors.
Given her number of FTAs, Mr. Murphy, and her history, I'm reticent to reduce the bond. If you get more specifics on this halfway house and somebody's going to take her straight from custody into the halfway house, and it has to be somewhere where she has to be placed, where she can't leave, then I can consider that. But I'm not just going to let her out to go to this halfway house without knowing anything more, without having some type of understanding of what the restrictions would be, and that she'd be going straight to the halfway house. So if you want me to reset this until next week for you to accomplish that, I'm happy to do that. Otherwise,
yes, Judge, that would suffice. You give me 1 week.
Okay, we'll put her back on for that's 4/21. And if you'll get that detailed information, we'll consider it at that time.
Thank you, Judge. Mr. Vasquez, I'll see you at the ACDC in the next day or so. Thank you, Judge. That's all I have.
All right. Have a good day, Mr. Murphy.
All right, next we got 15, Mr. Harris.
Okay. And this is also going to be a bond hearing?
That's correct, Judge.
Okay, can someone tell me what the current bond is?
What I have, Judge, is it looks like a $4,000 cash bond, this being a rearrest, but it looks like a bench warrant for this case, but in the amount of 4,000 cash, at least when I checked the jailing.
Okay, Ms. Stallworth, may I have the history?
Yes, Your Honor. He has 35 cycles. There's a 2019 out of Gwinnett for battery, family violence, first offense, possession of cocaine, and aggravated assault. There's another 2017 out of Gwinnett for theft of services, willful obstruction of law enforcement officers, a 2014 out of Gwinnett for theft by shoplifting, 2011 out of Fulton for aggravated assault, willful obstruction of law enforcement officers, fleeing or attempting to elude, and hit and run. There are 4 other convictions outside of the 10-year period. There was an 05 battery from DeKalb. There's a 2026 FTA out of Fulton, 2018 out of DeKalb, and 06 out of DeKalb. Nothing further.
Thank you. Mr. Sirocco?
Yes, Your Honor. So as you heard, multiple convictions here, several of which for violence. The 2011 ag assault conviction, as well as the 2019 ag assault and battery family violence conviction, and that was out of Gwinnett. Also the 2005, in addition to the FTAs. This was an incident from, it was from March 16, 2021. The victim's name is Danielle Ann Todd. The defendant was her friend. There were complications over he was having with his wife, and both those parties were under the influence of alcohol. He became physical and scratched her neck. There was another verbal altercation that was followed up by him then pushing her, causing her to fall to the ground and sustain a bruising to her left elbow. And I believe at the time he had an active warrant out of Gwinnett for probation violation and was arrested there. And here, again, the current rearrest, from my understanding, is for failing to appear for a jury trial. That was July 19th, 2022. And we're just now getting him back before us here in Fulton, Your Honor. We would ask that the bond remain as set, especially with a prior FTA, history of violence. And we would essentially ask that this be left to the trial court judge, as it is a bench warrant here.
Mr. White?
Yes, Your Honor. Mr. Harris has actually been incarcerated. That's the reason he missed his court dates. I have in front of me proof of incarceration from December of last year until recently released to Fulton County. Additionally, he was in Rochester State Prison before that for about 18 months. I did email my investigator yesterday to confirm that. She reached out to the prison, but the person that can do that, they can verify those dates, was off yesterday. So we were not able to verify that. But I also have a request for production order from him while he was incarcerated in Gwinnett County, asking that be transferred to have this case resolved. So we know for a fact that he's been in since August of last year through today. I'm almost certain that he was in before that, and my investigator is going to follow up today. Of course, yesterday we could prove that. Additionally, this case is 5 years old. Again, it's over 5 years old at this point. The last conviction I heard was 7 years ago. We would ask that you, at the very least, reduce this to a $2,000 good bond, if not a signature bond at this point.
Okay, Mr. White, if he was in custody on July of 2022, when he missed the court date, is my understanding, then I will give him a signature bond, but I'm going to need some proof that he was in custody on that date in 2022. So if you want me to give you, if you want me to give you time to get that done, I'm happy to do that. You can even if you get it done by Thursday, you can play, well, I won't be the judge, so I can't say what they would do, but I will give him a signature bond if you can prove to me that he was in custody on the day that he missed this date.
And Judge, understood, we reset it to.
Okay, so reset till next Tuesday, 4/21.
Yes, Judge.
Okay. And once you get that information, if you will go ahead and send it to Ms. Young so that I can review it beforehand, and also, of course, Mr. Sirocco. We can get this matter handled quickly next week.
Thank you, Judge.
All right, so I'll see you back next week, Mr. Harris.
All right, 22-23, Mr. Kelly. Kelly. I need to speak. No. No.
Yes, what are we doing with Mr. Kelly this morning?
I need to speak with Mr. Kelly, Judge. He was in court downtown yesterday, so I was unable to speak with him.
Okay, so can we go to someone else to give you that opportunity?
Absolutely.
Okay. Any of Mr. Haddad's or Mr. Mergler's cases that we can take?
All right, I only had the ACDC folks, and I only had that one plea, Judge.
Oh, okay. Thank you, Mr. Dodd.
But I'm here for the 11 o'clock if they ever appear.
One community plea on 25. Yeah, that's down to this case, 121. All the
Grace, are you with me?
Yes, sir.
Would you mind calling Malcolm Dill, who's on the DB bench warrant calendar, and see if he can join us early?
Yes, sir.
Thank you. I appreciate it.
And if I can request one of the litigation managers to give me Mr. Dill's number, I can also call him as well since I need to speak to him.
Yes, sir.
Thank you.
Yes, Mr. White.
Judge, we are somewhat ready, I guess, for position 23. Position 22, he entered a plea downtown yesterday in front of Judge Porter. I'm not sure why they did not also handle this case. So I guess
Okay.
we would like to go non-negotiable.
All right, so let's just make sure, Ms. Young or Mr. Sirocco, are you able to verify that in position 22 that a plea was entered yesterday?
Yes, Your Honor, a plea was entered yesterday.
Okay.
Does
And
appear to be the case, Judge. I'm just looking, because which one did you say, Mr. White? It was
The older case.
the older one, 7301B. Okay.
And somebody from our office handled it, so. And I've got a question for JCS if available. It's been a while since I've handled one of these cases, but in my experience, Judge, JCS does not take child support fees for probation.
Is anybody on from probation? Or
And Your Honor, that case from yesterday, he's released the pad.
Correct, Judge. He's supposed to go to 10 o'clock tomorrow morning.
say it again for me, Mr. White.
He's supposed to be released to pad 10 o'clock tomorrow morning on the other case.
And Your Honor, if I may, just so the court, I got a call yesterday from Samaya Patton, who's our public defender and Judge Porter, and she told me that they handled that case, the 25 CR case with pads. I don't know why the 25 the other case was not handled yesterday. I have no idea. So I don't know if they were not aware of this case or not. But anyway, we're here, and I've communicated that to Mr. White. And I just want to give the court just very brief background of what I know.
Okay. So do we know what the sentence was? What was he sentenced to in that first? Because I'm willing to follow that because it's with the additional 1,050, whatever that was. If we know what the sentence was.
It was balance probated, to pay $10.50 purge within 60 days. Waive 2 months of, waive the first 2 months of probation fees. Credit for time served, 68 days, and then he's gonna be released to pay it.
Okay. And so if you want this case to follow that case with the payment of the $1,050, I think that would be probably the best way to handle it.
Judge, and we're willing to go with that, but like I said, I don't know if you know different or what. And like I said, it's been a while since I've had an abandonment case. I didn't think that probation would take a case where the payment was child support. And that's why.
Okay, well, he's gonna have a problem one way or the other because he's already been sentenced to probation. So they're gonna have to deal with that somehow as well.
And you're right.
Can someone give probation a call for the court for me so that we can get somebody on to clarify this?
We think they're on, Your Honor. Nobody is answering, but we'll give them a call.
Okay.
And Judge, we would go, like I said, we were gonna go non-negotiated. If probation will take this, then we're fine with that. But we were going to ask that he not have to do the parenting course. This really doesn't have anything to do with parenting. It's gonna cost him more money. It'll be taken away from the children at some point. And then obviously ask that once the payment is made, that the probation terminate.
Okay, and again, as far as that goes, I would like it to track what Judge Porter did. So if I'll certainly waive the 2 months of fees. If she allowed it to terminate, then I'll allow it to terminate as well. But if not, I'll just I want to track what she's done. It doesn't make any sense to me that one does and one doesn't, or vice versa.
And Your Honor, JCS is about to come on, and I did send a message for them to handle both cases. When he was put on this calendar, I'm not for sure what happened, but JCS should be logging on to answer that question for you in a moment.
Okay, thank you, Ms. Young. Can we go to someone else while JCS? Oh, here we go.
Good morning, Judge.
Yes, good morning. The question that the court has and counsel has is that yesterday, apparently, Mr. Kelly was sentenced to probation to pay a purge amount of abandonment of dependent children. We're just trying to verify if probation takes those types of cases and would accept
Child
the,
support?
yes.
No. We don't have that information. Sorry, Judge. Good morning, Judge. How you doing? This is
Good morning. Yes, good morning.
Okay, so we can't accept those because we don't have that. They have a portal or something they have to send their money to, or the child support information for their some kind of ID that they have. So how do we don't know how to pay them? I don't know. We always had that problem with the child support cases.
Okay, well, Mr. White, I'm willing to, he's gonna have a problem regardless. I think this needs to go back to Judge Porter so that they can figure out what they need to do in this regard. Apparently, no, it was accepted yesterday to go through probation. And if probation won't accept it, then he's gonna have a problem with that underlying case where he's already been sentenced.
Probation does not take the case for 20 years. So,
why don't we do this? Why don't we have someone get in touch with Judge Porter's chambers today? We'll put this back on for Thursday. If we need to go back to Judge Porter's court, then that's a possibility if they can somehow amend the order, but let them know what the problem is so that we can get it all rectified at one time.
and Judge,
I'll do that, Your Honor.
would you consider a time served plea at this point? He's been in jail 70 days as of today.
Well, that's not going to help with the with his other sentence.
Well,
right.
Well, and that can be figured out at a later date. I'm dealing with the case that I have in front of me. He's to be released to PAD tomorrow to give him a potential start to where he could actually make good on his child support issues. If we just keep him in jail, that's never going to change. So, I mean, they can readdress the other case while he's out, the one that he pled to yesterday. But I would ask that we just do a time served offer at this point. And if, he is not up to date, if the mother can take out a new case every month that he doesn't pay. So,
Yeah,
but
we would object to that. It's if he's getting out on a time served plea, he is by definition not adhering with child support payments. That is exactly what is happening. That's why we're asking for the payment of the child support that he missed.
and Judge, we're not arguing the facts of the case. We're arguing practicality. If the goal of these child support cases is to get the money to the children, him sitting in jail is going to be not getting anywhere near that. He has no opportunity to get housing, work through PAD, to find a job to where he could actually provide money for the children.
Okay, well, you all got me between a rock and a hard place because I think that he needs to pay I don't want him sitting in jail, and I understand your argument, Mr. White. I also understand that I need for him to pay his child support of $1,050. If I have not handled anything like this, can I give him a signature bond on this abandonment of dependent children, have him go back at some point in time to Judge Porter so that she can handle both of these cases, so that he can make his PAD appointment tomorrow and have a place to reside?
Obviously, we would be fine with that, Your Honor.
Is it possible for that, Judge? I'm just asking. My understanding is what the
I'm
purge
trying to
amount
figure out
is. Yeah,
I'm trying
I
to
know.
figure out a solution. So,
I mean, Your Honor, it is, it's within the court's discretion because the criminal case is not going away by giving a signature bond. So whatever amount he owes, purge amount, whatever it is, would be part of the criminal sentence when and if he pleads guilty or goes to trial. So I think that issue, Judge, is, whether the court decides to give him a signature bond, that's entirely within the court's, regardless of if he owes and how much he owes.
okay, well, I think that's the best solution at the present time. Mr. Dodd, would you let your prosecutor know that's in Judge Porter, the issues that we're having here? And maybe they can, Ms. Young can let the litigation manager know as well.
Yes, Judge, I alerted my attorney by text just now, Judge, to let her know what's going on. And I'll update her if the court is inclined on a signature bond. I'll make sure to let her know to reach out to Chambers and make sure that this case gets addressed with Judge Porter.
Okay, all right. So if that's the case, then what I'll do is give him a $5,000 signature bond through pretrial level 1. Any other conditions, Mr. Sirocco, that you would like the court to place?
No, Judge, not at this time.
Okay, all right. So then this case will be returned to Judge Porter so that he can handle it at a later time, and we can figure out what's going on with the payment to probation or how it's going to get it paid.
If he does, Judge, pay the amount for this case, we'd be inclined to dismiss the charge.
I understand, Mrs. Rocco.
I'm just letting him
I
know.
think, yes, I understand. I think the issue is that the ability to pay.
Right.
All right, so Mr. White, if you'll prepare that for the court, I'll sign it.
No problem, Judge. We'll get that to you. Thank you, Ms. Haddad.
Next is position 7, Ms. Cutler.
Yes, Ms. McLeod, this is your case. Good morning.
Good morning, Your Honor. This is going to be a time-served plea for Ms. Cutler.
Okay, good morning, Ms. Cutler. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
So help me God.
Thank you, ma'am. You can place your hand down. Yes, Mr. Soroka.
Yes, Your Honor. On the criminal trespass, state's recommendation is time served. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Yes. We do still stipulate.
If nothing further, Ms. Cutler, it's my understanding that in case 26 CR 002266D, you wish to plead guilty to criminal trespass, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Cutler. Good luck to you, ma'am.
Thank you.
Yes, ma'am.
Thank you, Your Honor.
Ms. Middleton, come on, you up there, come here.
All right, number 10, Ms. Favors.
Okay, and what are we doing with Ms. Favors this morning, Ms. McLeod?
Your Honor, I haven't yet had the opportunity to speak with Ms. Favors.
Okay, can we make Ms. Favors available for Ms. McLeod to speak with?
Your Honor, can we do it after we finish with Ms. Jordan, who is Ms. McLeod's client?
Yes.
Okay, all
Yes,
right.
that would be perfect because I've already spoken with Ms. Jordan.
And what are we doing with Ms. Jordan this morning?
This is also going to be a negotiated plea, and I want to state, Your Honor, that her daughter is on the line as well.
Your Honor,
Okay.
my name is Carleria Robinson. How are you?
I'm doing well, Ms. Robinson. I'll be with you, and I'll give you the opportunity to speak if you'd like. Ms. Jordan, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please?
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Nothing but the truth.
Okay, you can place your hand down. Thank you, ma'am. Yes, Mr. Soroka.
Yes, Your Honor. On count 1, for position 18, the battery, state's recommending 12 months, serve 120 days in jail, credit for time served, balance probated, 12-week anger management. We're recommending an MH evaluation and any recommended treatment. No further violent contact with any emergency personnel or healthcare providers. That is to include the victim here, Miss Olivia Romero Reed. We are also recommending 40 hours community service. Count 2 would merge with count 1. And we have spoken with the victim. She did indicate that she wanted this case to be upgraded as a felony, given that she's a paramedic. She was out of work for 2 weeks and was seen at the hospital on the day of attack and was on leave according to the doctor's orders here. We lament for the difficulties that she's been through as a result of the defendant's behavior. We also want the defendant here to get an MH eval as soon as possible. We do see it fit to deal with this here in state court with the resources that we have here. So we are recommending that 120-day sentence, Judge. We would ask for her to be on reporting probation the entire time. This is a public safety case. There is a previous terroristic threats and acts from 2024 of which she was convicted. So we would ask that defense stipulate the factual basis, venue, and identification for purposes of the plea.
You do so stipulate.
And if we could
Okay.
sound for Miss Romero Reed, I believe I did see her online earlier, if she's still online and wishes to speak.
Yes, Ms. Romero Reed, I see you there. If you would like to address the court, now is your opportunity. If so, I need for you to raise your right hand for me, please, ma'am. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. What would you like to tell the court?
Hi, just to be clear about how the attack occurred, I'm a paramedic and she was my patient. So we were there only to help. The attack basically came out of nowhere, and I was cornered in the ambulance and beaten with her phone. Like he said, I was out of work for 2 weeks per the doctor's orders. I had a concussion, I had hematomas all over my head, persistent headaches, among a number of other neuro issues that have which is wonderful, they have cleared up so far. But this attack was fairly vicious, and as far as I understand, she has a number of other convictions. Thus my recommendation or my ask. But that's all I wanted to add. Thank you.
Thank you, Ms. Romero Reed. I appreciate you being here this morning. I'm sorry that you had to go through that.
Thank
Good
you.
luck to you, ma'am.
Thanks.
Yes, Ms. Robinson, I see that you're on the line as well. If you would like to address the court, now is your opportunity to do so. If so, I'll need for you to raise your right hand for me, please, ma'am. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. What would you like to tell the court, ma'am?
Yes, my mom suffers bipolar schizophrenia, and we had been trying to get her medicine, trying to get her to get to the hospital. And she has also, that was the reason the police got over there that day, because she was trying to get her living situation with my brother, the case that was previously in 2024. She was trying to get him to leave her house, but she couldn't. No law, no anything, nobody would help her. So she relapsed and had an episode. We tried to, before that, she had an episode where guns were being pulled out on her. People were jumping on her. I was getting phone calls. It was just beyond crazy. And I'm so sorry that Miss Olivia has gone through that. I'm so sorry, but she was having an episode. She was having a real bad episode. And I just asked that the court give her mercy.
Okay. Thank you, Ms. Robinson. I appreciate you being here today as well.
No problem.
Ms. McLeod?
Yes, Your Honor, it's going to be a negotiated plea today, and I would ask the same, Your Honor, as her daughter has asked for her, because she does have some issues.
Where is she going to reside once she is released from custody? What is the plan?
She has her home. We have cleared it out. Everybody's gone. We're just waiting on her to get home so that she can be safe. Nobody's there, so she'll be there alone. And she'll have me to go check on her and make sure she's okay.
How long has she been in custody at present?
It's been more than 2 months, that's my understanding, but the state will have a more accurate picture of how long she's been there, Your Honor.
I can't advise as to the days she served, Judge, but I can tell you that this was not intended to be a time served plea by any stretch.
Well, I'm concerned about her home plan. I'm concerned that, placing her on her own. I don't know if her issue is with anger management, so I don't know how effective that would be. Community service, I don't know, given the circumstances of the case. I think that given her, what's been told to me regarding her mental health, that's what I'm most concerned about, and that this does not happen to someone else, and that we don't set her up for failure. But I am uncertain as to what would be best for her.
Your Honor, I was concerned about her ability to do the community service as well, but when I discussed it with her, she agreed to the terms.
Well, I understand that, but that she's agreed to the terms, and I'm just concerned about the terms. I would like for something to be done more for her mental health, and I'll just be honest, I don't know what that would be, what we could do to assist her more.
If I may, I'm sorry, is there a way to do an inpatient sort of psychiatric ward or something that we could get her on the medication? I'm sorry, I don't really know how
No,
to work.
the court, I'm not sure the court has that ability to be able to do that. But thank you, Ms. Murray. She's gonna be in custody regardless. I would just like a better plan for her. So I'm not sure if, you know, if we can put our heads together and think of something that would be more of assistance to her as opposed
Maybe
to
mental health court, Your Honor. I don't know. That
She
might
doesn't
have some
qualify.
more structure.
Ms. McLeod, she doesn't qualify. I checked on that.
Hey, Your Honor,
And it's
Your Honor, I sent you the days in the chat, how long she's been in.
Okay, thank you.
You're welcome.
Okay, so I think I want to do this, Ms. McLeod with Ms. Jordan today, since she's going to be in custody. Let's reset her for 1 week to see if we can come to some kind of better agreement with her. And if we can't, if once you put your head together, we cannot, then I'll accept the plea as negotiated. But if we can think of anything to better assist her once she gets out, I'm certainly willing to consider that as well. Okay, so I'm asking that Mr. Sirocco, you and Ms. McLeod in the next week or so, maybe put your heads together and think of something that we could do so that she won't come back here.
And
And I'm
Judge, can
not-
I add something? I'm sorry, I didn't mean to interrupt you.
No, you're fine, Ms. Robinson. Yes, ma'am.
Yes, my mom, she's just as sweet as she wants to be when she's on her medication. And I think the issue is when she's stressed out or have like too stressed out is where she doesn't take her medicine. And like you said, I think there needs to be a treatment plan for her mentally.
Okay. Ms. McLeod, would you also speak with Ms. Robinson in the meantime to see what treatment she is receiving, the doctors that she's speaking with? I'm certainly willing to consider placing in the order that she is to obviously stay on her medications and that she is to see her doctors on a regular basis, if that's the case.
Yes, Your Honor.
Okay, so find out more for me about what treatment she's currently receiving and with whom, so that we can consider that, okay?
Yes, Your Honor. I'm putting, Ms. Robinson, please check your chat.
Ms. McLeod, you may have to call her, and it looks like she may have dropped or logged out by error.
Okay.
All right. Thank you. We'll be back. We'll place her back for next week's calendar, 4/21.
Yes, Your Honor.
All right. Thank you all. Does probation have something more for me?
I do. So I talked to my manager and they talked to corporate. So we can accept that child support. We just put it as restitution.
Okay. All right. Very good then. Thank you. Did you hear that, Mr. White? probation says they can't accept the child support as restitution.
Okay.
Okay. Is he still in the court there with us?
He's not, Judge. I've already taken him back.
Okay.
I'm sorry.
All right. Well, thank you all for the clarification.
No problem. You're welcome. Thank you.
Who can we take next?
11, Mr. Ferrera.
This is a non-negotiated plea, Judge.
Take it, this the amount of days he's been in custody?
Yes, Judge.
How long has he been in custody?
Been in custody 41 days at this point.
Yes, good morning, Mr. Vieira. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? The other hand. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Say it again. Okay, we still can't hear you. Okay, thank you. You can place your hand down. Ms. Stallworth, may I get the history, please?
Yes, Your Honor. He has 16 cycles total. He's currently on probation for case number 25 CR 0072228Y for criminal trespass. Also on probation, also on first offender probation for case number 24 SC 003872, willful obstruction of law enforcement officers, criminal trespass, and terroristic threats and acts. And also on probation for case number 25 SC 004474, criminal trespass. Nothing further.
Yes, Mr. Siraka.
Yes, Your Honor. This was March 4th, 2026. Officers were conducting a premise check of the Exxon located at 1105 Holcomb Bridge Road in Roswell. They observed a male later identified as the defendant. He was standing up against the glass windows next to that location with his arms downward. He appeared to be urinating, or at least preparing to do so. They approached him. And they recognized him from previous interaction as the defendant. He was not doing the aforementioned, they determined, but he was confirmed to have been issued criminal trespass warning from the Holcomb Bridge Road location, that Exxon. And when asked, he did say he was aware of this. And also, he did state he had a bowl on him. He was found in possession of a cylindrical glass tube used for smoking drugs here, Judge. I did see, in addition to the history that we did go through, there is a 25 SC 004474 criminal trespass that was amended from criminal damage to property in the second, which he was convicted October 31st. But on that, he was sentenced to 12 months, served 3 months in confinement with ADET, and that was for damaging the glass door of a food mart with that 25 CR case that he's on probation for. He's in violation of that here. It's the same Exxon. And he was sentenced to 12 months, serve 120, balance probated with a stay away from that Exxon, along with 40 hours community service and BHET. I have 3 other convictions here. 24 CR 002851Y, criminal trespass, simple battery against a law enforcement officer, convicted December 2024. 24 CR 001860Y, criminal trespass, convicted in 24 also, and a 23 CR 005958B, criminal trespass conviction. The 3 I just mentioned were also at the same location, the 1105 Holcomb Bridge Road address, the Exxon in Roswell. So he's been a persistent problem for them for several years now, and it seems just after he's I released him, less than a few months. He's back at the same location, Judge. So the state's recommending criminal trespass for count one, 12 months, serve 180 days, credit for time served. And again, this is an incremental step up from the last sentence, the 120-day sentence from December of last year. 12 months, serve 120 days, credit for time served, balance probated. Stay away from the 1105 Holcomb Bridge Road, Exxon. Count two, the possession and use of drug-related objects, 12 months probation concurrent with count one, ADET, 80 hours community service, which is again a step up from the 40 hours that he was sentenced to in December. Stay away from 1105 Holcomb Bridge Road, that Exxon. Excuse me, that would be consecutive. We'd be asking for a 24-month probationary sentence here, Judge. With the service of 180 days. We would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea. And that, I believe, is all for the state.
Thank you, Mr. White.
Your Honor, as previously stated, he's already been in jail 41 days at this point. We're just asking for time served. Additionally, he was just revoked on March 31st for a year, so he's not getting out anyway on a 24 SC 00387 case. So we're just asking for time served. We've got a year, almost a year to do on that case. Any amount of probation we think is setting him up to fail as well. So he's already getting plenty of probation going on in other cases. I do not believe 80 hours of community service is going to move the needle.
What's the issue, Mr. White? I mean, even if I do what you're asking me to do, and he's gone back there a number of times, what can we do to help this young man as opposed to, if is it housing? Is it
Judge, if I could have a minute. Judge, I just wanted to ask his permission. He has a substance abuse problem, and he is going back home and going to rehab once he gets out. Of course, that won't be until March of next year at this point. So again, he won't be released for another year.
all right? So I'm going to accept the state's recommendation as far as position, as far as the criminal trespass goes. Especially given that he's not going to be getting out anytime soon. As far as count two, the possession and use of drug-related objects, I do think at a minimum he needs to have the ADET. I am going to keep him on, so he's going to have that. I'm going to keep him on probation. Once he completes the ADET and he's on probation for the first year, I'll have the second year go non-reporting if he successfully completes the ADET.
Judge, would you consider waiving all of his probation fees, considering it's going to be a year before he's released anyway? No job.
Okay, that's fine with the court, Mr. White.
Thank you, Judge.
Is that what he wants to accept?
Once Judge, we can go forward with that.
Okay. If nothing further,
Did defense stipulate? I'm sorry, if I missed that.
We do stipulate for the purposes of plea.
All right.
okay. Mr. Ferrier, it's my understanding that in case 26 CR 001482A, you wish to plead guilty to criminal trespass and possession and use of drug-related objects. Is that correct? Speak up for me. Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept your plea for the criminal trespass, 12 months to serve 180 days, credit for time served, 41 days, balance probated, stay away from the Exxon on Holcomb Bridge Road. For the possession and use of drug-related objects, 12 months to serve 180 days, credit for time served, 41 days, balance probated and ADET, stay away from that Exxon on Holcomb Bridge Road. This will run consecutive to count one if you complete the terms of count one successfully. The first year, the second year will be non-reporting. I'm going to waive all of your probation fees to help you stay on your feet. Good luck to you, sir.
Thank you, Judge.
All right, going back.
Your Honor, may I make an announcement on my other two cases, please?
Yes, Ms. McLeod.
Miss Favors is going to be a waiver, and I would like her placed on the next available calendar. And Mr. Serchion, the state apparently has asked for a reset, Your Honor. And I think somebody said he has a private attorney.
Yes, he appeared earlier in the day.
Yes.
Okay, so position number 10 will be a waiver, and that case will be returned to the division judge.
Thank you, Your Honor.
Okay, yes. Anything further?
Nothing further, Your Honor. May I be excused?
Yes, have a good rest of the day. Thank you, Ms. McLeod.
Thank you. You too.
Your Honor, on position 11, did you take the community service away?
Yes, I did.
Okay, I just wanted to clarify. Thank you, Your Honor.
Okay.
All right, number 30, Mr. Roberts.
Mr. Mergler, good morning.
He's on his way, Judge.
Okay.
Morning, Judge.
Yes, good morning, Mr. Mergler. What are we doing with Mr. Roberts this morning?
Mr. Roberts, let me just check the notes. I believe we are going to proceed with a not guilty.
Okay, so a waiver will be filed for Mr. Roberts. Mr. Roberts, good morning. Your case will be returned to the division judge. You'll get notification of your next hearing date, sir. Good luck to you.
All right, 31, Mr. Rowland.
This is going to be a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Rowland.
How you doing?
I'm doing well, thank you, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you. Mr. Siraka?
Yes, Your Honor. On position 31, the theft by shoplifting, state's recommending 12 months served 22 days. Credit for time served, balance probated. We are recommending BHET, an anti-theft course, and a stay away from all Walmart locations in Atlanta. It's my understanding that he's been trespassed, at least as of April 3rd, from 15 different Walmarts in the surrounding metro Atlanta area. We would be asking for a stay away from all the Walmart locations to include the 844 Cleveland Avenue address in East Point. And 40 hours community service. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Yes, Mr. Mergler.
Yes, Your Honor. We are amenable to those terms. we were going to ask for waiving probation fees so he can get back on his feet. Money has clearly been an issue, so I would ask for that.
Okay, Mr. Rowland, it's my understanding that in case 26 CR 002249D, you wish to plead guilty to theft by shoplifting, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Rowland. I will waive the first 2 months of probation fees to help you get on your feet. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
All right, thank you.
You're welcome.
All right, 34, Mr. Sims.
What are we doing with Mr. Sims this morning?
We are going to, we would like to reset Mr. Sims's case for 1 week. He has a hearing in another matter on Friday.
Okay.
However, we were going to ask if it was possible to renegotiate the bond. This was reduced from a felony relatively recently. And we feel that the $10,000 bond is quite a high burden given that it's a misdemeanor.
Okay, I will consider that request next week if you choose to request it at that time, but we'll see what happens with this hearing. I'll reset him for today until next Tuesday, 4/21.
All right, that's bill 35, Mr. Snow.
Okay, and Ms. Bilal or his case will be reset till next week. We're happy to have you here at that time if you choose to be with us. Thank you, ma'am. I'm sorry, tell me who this is again?
35, Mr. Snow.
Yes, and what are we doing with Mr. Snow today?
How you doing, Jordan?
I'm doing well, thank you, sir.
So, we will, with this one, he's open to a plea, Your Honor. However, with the significant amount of time served being asked, and 24 months of probation, we find that both of those requirements are quite heavy. He'd prefer to do a little extra time and not have any more requirements if the court is open to that. But otherwise, he would probably proceed not guilty to that.
Okay, well, do you want me to hear the case first? I'll have to before I can make a determination, so is that, all right, so good morning again, Mr. Snow. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Ms. Stallworth, may I get the history, please?
Yes, Your Honor, I'm working on it, but he does have 27 cycles total. He's currently on probation, case number 26 CR 002698 for theft by shoplifting. And one moment, there's an FTA in 2023 from DeKalb County. There's a theft by shoplifting out of the city of Atlanta that was sentenced February the 27th of this year. There's a 2022 theft by shoplifting also out of the city of Atlanta. There's an FTA in 2021 from Fulton. Another FTA in 2020 from DeKalb. A simple battery from 2019 out of DeKalb. A forgery 4th degree from Clayton County in 2020. And that's all. Nothing further.
Thank you. Yes, Mr. Sirocco.
Yes, Your Honor. I looked into his history as well. I see at least what appears to be 5 theft by shoplifting convictions, 2 NOLOs for the same from 2026. A lot of these are recent, stemming from 2021 up through 2026. And they're at from what I can tell, the majority of them are at the Exxon, which is just a couple of blocks over from this. I know he was I believe he was convicted before this was returned to us from Superior Court. This was originally a criminal trespass, criminal damage to property in the second. There was a 26 CR 001823 case for theft by shoplifting. He was convicted of that, which was at the Exxon nearby. This incident was March 17th, 2026. The address is 312 Auburn Avenue in Atlanta. It's the Sweet Auburn Bottle Shop. Law enforcement responded to that location in reference to a criminal trespass and theft. They made contact with the store owner, Mr. Gungoran. Defendant had previously been criminally trespassed from the property, and this is due to prior incidents. On the date in question, he was seen approach the business. Upon seeing the defendant approach the business, Mr. Gungoran had secured the front door to prevent him from entering because he knew that would be problematic. But the defendant then forcibly pulled on the door, damaging that lock, and unlawfully entered the business, then proceeded to take 50 bottle shots of alcohol, and then exited the location. And officers, when they attempted to detain him, he actively resisted, fought with the officers. It took 3 officers to actually get control of him. He was then handcuffed and ultimately fully secured and detained. I did see as well criminal trespass damage to property 2022. That was for throwing a brick through the window of the Exxon at 440 Edgewood. And I know, I believe as well there were other criminal damage to property in the second convictions, if I'm not mistaken. I just don't have those in front of me. But that simple battery against law enforcement officer 2024. He's been a problem for this area for a good while, Judge. And this is a matter of public safety. You've got risk of reoffense here. We're asking for, on count 1, criminal trespass, the 12 months probation concurrent with count 3, BHET. On count 2, 12 months probation consecutive with count 3, with an anti-theft course, and a stay away from the property, that Sweet Auburn Bottle Shop in Atlanta, 312 Auburn Avenue. As well, count 3, we're seeking 12 months served, 220 days, credit for time served. Balance probated, ADET. That does seem to be a recurring issue. The recent criminal trespass, the recent theft by shoplifting, which he was convicted. It's multiple, actually. The theft of alcohol seems to be a recurring problem, Judge. Recommending ADET, an 80 hours community service. As for count 4, the 12 months probation concurrent with count 3, $300 fine. And if I didn't say it, we were requesting to stay away from on count 3 as well, from the Sweet Auburn Bottle Shop in Atlanta. And I believe I did see, if I'm not mistaken, there's an open fleeing and eluding. But yeah, that's the state's recommendation here. We would ask the defense stipulate the factual basis, then leave an ID for purposes of the case.
Your Honor, I'm sorry, I don't mean to interrupt. There is an open case, 25 PI 010454 for fleeing or attempting to elude, endangering a child by driving under the influence of alcohol, reckless driving, expired tag or unregistered vehicle, and knowingly driving on a suspended, canceled, or revoked registration.
Thank you, Mr. Oler. Yes, Mr. Murdock.
Yes. I'm sorry, is that 26 PI, are, that is still open, you're saying?
25 PI, I believe. 010454.
Okay.
Last I checked.
Look, Your Honor,
This was the 26 PI case that came to us.
can I have a moment with the client?
Yes.
Thank you for your patience, Your Honor.
Yes, Mr. Murgler.
I believe my client would like to proceed with a non-negotiated. It's a significant amount of probation that's being asked for, and a significant amount of time to serve that's being asked for. And I feel that the court will be more fair than the state currently. I'd like to point out that his housing was unstable when he was picked up on this case. He has since been able to, rekindle his relationship with his mother and has a place to stay when he gets out. And I'll also say that his son has recently gotten into trouble, and he is very, very worried about his son. He would like to get back to his family and prioritize his son. He said he did not want his son to be another statistic. And I really took that to heart. I think that he is being truthful when he says that, and he would like to focus on getting his life back. He has no problem with any of the behavioral health terms, the alcohol drug treatment. He wants to do that, Your Honor. And he also was saying that he would find a 30 hours of community service on top of the 80 hours, so for a total of 110 hours of community service. He would find that more meaningful as he gets back on his feet than paying some $300 fine. He said he'd like to engage and really, get back on his feet.
So what's the request, Mr. Mugler, as far as
Yes, so the request
being non-negotiated?
Yes, the request would be to serve till the end of this month, out on the last day of the month. He is willing to do 12 months supervised. 12 months supervised. If there's going to be any more, we'd ask it to go non-reporting for the probation. Be clear, 12 months supervised probation. Anything more, he would hope for unsupervised. And he's happy to keep the behavioral health treatment, the alcohol drug treatment, the anti-theft course as well. I didn't mention that earlier. The anti-theft course, all that is fine. And we would ask for 110 hours of community service in lieu of fines.
How many days has he been in custody at present?
He has been in custody for, it looks like, 26 days, Your Honor. Actually, no, I might have that wrong. 28 days, I believe.
Okay, so what I'll do, if he chooses to accept the court sentence, that I'm going to accept the state's recommendations for count 1 and count 2. For count 3, it will be 12 months to serve 120 days. Credit for time served, the 26 days. He'll also have to do the ADET and 100 instead of 80 hours of community service, it'll be 100 hours of community service for count 3. I'll accept count 4, but I'll convert the $300 fine to 30 hours of community service. I am going to run count 2 consecutive, but if he completes the first year successfully, meaning that he makes all of his probation appointments and that he completes all of the requirements within that first year, I will have the probation for the second year be non-reporting. I will also waive the first 6 months of his probation fees to help him get on his feet.
And that's with the stayaways, Judge?
Of course, with the stayaways.
He's amenable to that, Your Honor.
Okay. If nothing further, and did you stipulate, Mr. Margaret? Okay. Mr. Snow, it's my understanding that in case 26 CR 002262C, you wish to plead guilty to criminal trespass, theft by taking, criminal trespass and damage to property, and willful obstruction of law enforcement officers. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Sir.
You've been represented by counsel. Are you satisfied with his representation?
Sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, no, sir.
Okay, I'll accept your plea, Mr. Snow, with the sentence that's been articulated by the court. Ms. Young, did you get that sentence?
Yes, Your Honor, I did.
Okay. If no questions, that will be the sentence of the court that was previously articulated. You to stay away from that Sweet Auburn bottle shop as well, Mr. Snow. Good luck to you, sir.
Thank you, Your Honor.
37, Mr. Thomas.
What are we doing with Mr. Thomas this morning?
He is first and foremost hoping to renegotiate his bond. Is that something that the court would be open to at this time?
Okay, what is the current bond?
Current bond is set for $2,500.
It's a good bond, Judge.
Do you have the bond pulled up? Do you know if did I give it to him?
I can pull that up, Your Honor. And this for position 37, correct?
Yes.
Yes.
Mr. Thomas.
That would have been. This is Judge Williams' bond, Judge, from April 1st.
Thank you. Ms. Stallworth, may I have the history?
Yes, Your Honor. He has 14 cycles total, a 2022 FT out of DeKalb, a 2020 conviction from Fulton for giving false name, aggravated assault, possession of firearm or knife during commission. I'm sorry, hold on one moment. There's a battery family violence first offense from 2022 out of DeKalb County. One moment. A robbery in 2013. There was a first offender out of Fulton. Nothing further.
Thank you. Mr. Soraka?
Yes, Your Honor. This incident here from March 30th took place at 942 Hank Aaron Drive in Atlanta. Officers responded in reference to a dispute and observed another officer on scene already speaking with the defendant inside the residence. He was initially located hiding inside a closet within one of the apartment rooms there, stating that he and the victim had a disagreement earlier, but claimed it was only verbal in nature. They did speak with the victim, Mr. Marion Davis. He is 65 years old, and he explained that this was the second incident involving the defendant on the same day. Officers responded earlier. He says to report regarding the defendant physically assaulting him, slapping him to the ground, and taking his cane before throwing that over the fence. Here, he had approached the defendant in the second incident on that same date, struck him, knocking a bottle out of his hand onto the floor, and that it was also listed that the defendant stated that he had consumed alcohol prior to the incident. With his history, the aggravated assaults, possession of firearm or knife during commission and battery family violence conviction 2020. That was for attempting to stab the mother of his child. He was sentenced to 4 years probation. There's a escape from custody or confinement. I believe that was a conviction as well with giving false information, obstruction, but more so the other violent cases. I had that the 2022 battery family violence out of DeKalb. I didn't see first offender for that. I had a standard conviction there as well. Battery of a certain nature and obstruction 2022. That was a MARTA case. So that was a random individual there. And a simple assault and felony interference with government property conviction 2016 as well. So there's a lot of he's got a lot going on with violence in his history. FTA 2022 and probation violations 3 from 2024 to 2018. As such, we are recommending that the bond, the 2,500, remains set. It was fair and reasonable at the time that it was ordered, just less than 2 weeks ago. And we would ask that the court leave that as is and deny the defense request here.
Thank you, Mr. Mergler.
Yes, Your Honor. Mr. Thomas is a U.S. citizen, lives here, born and raised in Atlanta. He actually, this is part of the reason why we'd like to address this, Your Honor. He actually lives at 94 Hank Aaron address and listed as a stay away in the offer from the state, and I believe was part of the bond. So that's where he lives with his partner and his child, who he does have custody over. He's also said that not to litigate the case, I know that's not what we're here for, but just that the gentleman, the alleged victim in this case, it's listed as Marion Davis. He believes that is not his legal name, that the man's name is actually Jesse Davis. And yeah, I have a history of being acquainted with one another. He has helped this man in the past and says that this is false accusation and that he has been that his character has been maligned. So we would really renegotiate this on to either a signature or nothing more than 1,000, Your Honor. The facts are shapely, in my opinion.
And Your Honor, sorry for the interruption. He was not supposed to stay away from 942 Hank Aaron Drive. He's supposed to stay away from Mr. Davis' apartment, but we were never able to get the apartment number. He's allowed to return there, but he can't go to Mr. Davis' apartment. So, Mr. Sirocco, if you have the apartment number, that would be appreciated, but he is allowed to go to 942 Hank Aaron Drive.
Let me see if I do have that. I don't believe so, but let me check. Yeah, I do not have the apartment number there.
Okay, so the order says, Your Honor, He has to stay away. It says 942 Hank Aaron Drive, Mr. Davis apartment, and I just put slash the number because nobody ever gave us the apartment number.
Right. I remember this one.
And Mr. Davis.
Okay, I'm not willing to give him a signature bond, but I will reduce the bond to $1,000 good bond with all the conditions. Well, no further contact with Mr. Davis, stay away from his residence, no drugs, alcohol, weapons while out on bond. Okay, so if you'll
So from there, we're gonna go, not guilty, right? Yeah, we're gonna go not guilty.
okay, so waiver will be filed and the case will be returned to the division judge. You will prepare that modification, Mr. Mergler. We'll get it signed.
Wonderful. Thank you, Your Honor.
All right, 39, Mr. White next.
And this is Mr. White. What are we doing with Mr. White today?
Mr. White is, okay, we were hoping to proceed with a non-negotiate on this one.
I take it that the time in custody is what you're,
Yes,
how much time has he served?
he has served, it looks like, oh, sorry, I'm doing a little math. Looks like 168 days, Your Honor. That is,
How much?
he has served 168 days. And his, the other individual who was picked up with him earlier received a time served recommendation. And he would like the same.
Well, if he served 168 days and the state's recommended 168 days, wouldn't that be time served?
Yes.
We were asking for balance suspended for not to return to the location, that 673 Kennesaw Avenue, Atlanta address. It's the Vision Reality is the name of that location. And we would be asking for a social worker visit as well, just for housing for him prior to release.
Apologies, Your Honor. I missed the balance suspended recommendation. We are okay with that offer.
Okay, so it's negotiated.
Sorry, negotiated. Thank you.
All right, very good. Good morning, Mr. White. I'm doing well. Thank you, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Thank you, sir. You can place your hand down. Yes, Mr. Sirocco.
Yes, Your Honor. So for the criminal trespass, state's recommending 12 months, serve 168 days, credit for time served, balance suspended. We would be asking for a social worker visit to meet with them for housing prior to release, as well as a stay away from Vision Reality at 673 Kennesaw Avenue in Atlanta. We would ask the defense stipulate a factual basis, venue, and ID for purposes of the plea.
We so stipulate.
Thank you. Mr. White, it's my understanding that in case 26 CR 002265K, you wish to plead guilty to criminal trespass. Is that correct?
Sir.
Are you under the influence of any drugs or alcohol this morning?
Sir.
You've been represented by counsel. Are you satisfied with his representation?
Sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay. I'll accept the plea as negotiated, Mr. White. Good luck to you, sir.
Sure. Thank you.
All right, 40, Mr. White, next.
It's
What are we doing with Mr. Wilburn this morning?
he would like to enter a plea of not guilty. We would also ask for a bond hearing.
And he does understand that the state's recommendation for count one is 12 months to serve. How much time has he served?
He has done. I'm sorry, I don't have an accurate on that. I can look it up real quick. It's not up to
Is count one anticipated to be a time served plea or not, Mr. Sirocco? Do you know?
Yes, Judge.
Okay.
Your Honor, he served 10 days.
There's also, I just want to direct your attention back to there was a prior arrest I saw where he was booked in for 2 days.
Yes.
Appears to be the same one as well. So I think that would, not that I'm advising as such, but would give him 2 additional days on top of the 10.
So it's basically a time served on both, and he's not willing to accept that, is what you're telling me, Mr. Murbo.
Yes, sir, Your Honor.
Okay. What is the present bond?
I'm showing 3,000.
Can someone pull that bond up for me so I can?
I see, at least as far as I can tell, is that I'm seeing different things here.
I think it's 3,000. They said on the second charge, a reference total bond. I'm trying to decipher too.
Yeah, because
The total is 3,000.
in the jailing it says 3,000, but in the on the regular Odyssey screen with his profile, it appears to be 1,500. And either way, it's not clear as to the second charge whether that's a UJR or not.
Well, the note says reference total bond, so I guess it's 3,000, Your Honor.
Okay.
Well, yeah, it's 3,000 because they want us to reference the total bond. It's 3,000, Your Honor. 3,000 good.
Ms. Stallworth, may I get Mr. Wilburn's history, please?
Yes, Your Honor, I was working on it. But so far he has 9 cycles out of the state of Ohio, 7 from the state of Kansas. There's a 2026 conviction for criminal damage to property and domestic battery. That sentence date was January the 29th of 2026. There was another 2026 conviction that doesn't show the charge. There's a 2016 conviction for violation of protection order. 2015 for endangering children and promoting prostitution, a 2014 for domestic violence, an FTA in 2026 out of Kansas. That's as far as I have gotten. I'm sorry. I was still working on it.
Thank you, Ms. Stallworth. Mr. Sirocco?
Yes, Your Honor. I also had, I said 2026 FTAs. I'm not sure if, apologies if I missed it, but I saw burglary in the first 2 counts, 2021, and I see an open, and let me confirm that this is the case, 23 SC 186022, case out of Superior for first-degree burglary, second-degree burglary, theft by taking charges, criminal damage to property, the second-degree charges, and criminal trespass. And yes, that does appear to still be open. That's currently in judicial hold status. I did see a bench warrant was issued for that. It appears for April 2nd, 2026. Let Let's see. Yeah, so the state's recommending that bond remain as set. I understand this incident is older, but the allegations are nonetheless serious. Attacking a Mr. Mason C with an ice pick, Judge. He has stated to police that he has anger problems, wanted to kill the victim. They live together at it looks like 1069 Ollie Circle. And there was, excuse me. Yeah, he was observed sticking the victim with an ice pick here. And it doesn't appear that any sort of violence is let up in his life, given the history that pretrial read out. We think bond's appropriately set here with the FTAs and the violent history. We would ask that it remain set.
All right, given the offer and the offense date of being more than 10 years ago, I modify the bond. Mr. Mergler, it'll be a $5,000 for both. Each charge will be a $5,000 signature bond through pretrial level 1, makes for a total of a $10,000 signature bond through pretrial level 1. No further contact with the alleged victim, Mr. C. Stay away from his residence, whatever that is. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Wilburn. And what are we doing with position 36, Darcy Steely?
Yeah, he's gonna be an MH reset.
Okay. And that'll be, I guess, till next week, 4/21. All right.
And what position was Steely, Judge, if you wouldn't mind?
No problem. He was position 36.
Thank you.
You're welcome. So I think that takes care of the regular calendar.
What happened with Steely, Your Honor?
He's reset mental health, reset till next Tuesday, 4/21.
Okay.
Judge, I have a brief
Yes, Mr. White.
position 4 through 6. I do believe I announced waiver on that. We're actually going to reset that to 21st.
Okay, so Mr. Cooper is going to be reset till 4/21 as well. Mr. Dot, were you able to raise Mr. Dill?
Judge, I actually spoke to him. He can't seem to figure out Zoom. I sent him the link. He's called me repeatedly. I suggested he do the download the Zoom app. Other than that, Judge, so and for what it's worth, Judge, he did confirm that he did get the notice. He did tell me that he's disabled and he wasn't feeling well. That's why he didn't go to court. And a few days later he went, and that's when he got the reset date for Zoom. But I mean, like I said, I told him there's nothing I could do. That he needs to log on Zoom. But I did confirm his address for what it's worth, Judge. And I would also point out that it's technically a conflict case based on the notes from Odyssey. But obviously, I was going to assist for purposes of today's bench warrant set aside, but I can't do it without him.
Okay, well, maybe he can figure it out by Thursday. Why don't we just reset him until Thursday, see if he can figure it out by then.
That's fine, Judge, and I'll reach out to him again and see. Maybe he's got a daughter, son, somebody.
Right, somebody that can help him.
Who's a bit younger, but he seemed to be technology. He's worse than I am.
Okay, so we'll reset Mr. Dill till Thursday. If nothing more, Ms. Young, whenever you're ready to go over the calendar.
Position 1, jail jury. Position 2, jail jury. Position 3 was a plea. Position 4, 5, and 6 reset to 421. Position 7 was a plea. Position 8 and 9 was released. Position 10, jail jury. Position 11, a non-negotiated plea. 12, 421. 13, jail jury. 14, plea. 15 was a bond hearing reset to 421. 16, Hutchinson. Let me see what happened. Oh, released. Position 17 was a bond hearing reset to 421. Position 18, 421, 19, and 20, the same announcement, 421. Position 21, 421. Position 22 took a plea to Judge Porter. Position 23 was a bond hearing, 5K SOB pretrial level 1, and the case will be returned to Judge Porter. Position 24 and 25 and 26, jail jury. Position 27, 421. Position 28 and 29 of the same defendant released. Position 30, jail jury. Position 31 was a plea. Position 32, 33, and 34 reset to 421. Position 35 was a non-negotiated plea. Position 36 was 421, mental health. Position 37 was a bond, 1,000 good. Returned to the division. Position 38, jail jury. 39 was a plea. 40 was a bond hearing, 5K SOB pretrial level 1. Position 41 and 42, jail jury. And the plea calendar was a plea. That completes the call of the calendar, Your Honor.
Your Honor, the position number 38, I may have misheard. Francis Tucker, that was a jail jury, correct?
That's correct.
Okay, I apologize. Thank you.
Oh, and what was position 39?
39 was a plea.
39 was a plea, and yeah, could you let me know if you see any other null process that I need to send you? Anything that I owe you besides Patricia Harkness, count 2, as part of that plea? I don't have any others written down.
I'll check and see it. I'll email you.
Okay.
All right. If nothing further this morning, thank you all. Hope you have a good rest of the week, and we will see you next Tuesday.
You as well, Judge.
Have a
Thank
wonderful day, Your Honor. The orders will be coming as soon as they send them to me. Mr.
Okay.
Mr. White, could you please tell Mr. Mergler to send me all his paperwork? Thank you.
Ms. Young, I'll get them back to you as soon as I can. I'll be out of the office for a while, but you'll get them as soon as I return, okay?
No worries, Your Honor. I have stuff to do for Judge Wolf. I have to help him next week, so I'm here. for
Okay.
today.
All right. Thank you.
You're welcome.
Hey Chanel, did you send my message?
I just saw it, yeah.
Okay,
You want
thank
me to send you the completed one after I get done with
Yeah,
it?
with the announcements.
Okay, cool.
Thank you.
Okay.